first in our programme. So we run it by the school year. So it's sort of back to school today. So it's, as you will see, an introduction to NEC contracts. So as we go along, I'm going to be talking about further seminars and webinars that we will run through the year that go into more detail in some of the things. So today is sort of two things, a sort of flavour of the detailed seminars that we'll be looking at later on through the year. But also that sort of high level review that I hope will be good if you're new to NEC, but also helpful as that sort of, sometimes it's, you know, good to be able to step back and think, yeah, that's, I've forgotten about that. That's a, you know, high level point. That's the structure of the contract. So hopefully it'll be useful to all sort of levels of experience with NEC. So if we can just move on, probably a couple of slides, Jen, please. Lovely. So on the agenda, we're going to look at the structure of the NEC contract. So that's the structure of the document itself. You know, if you buy the contract or the subcontract. We're also going to look at all the different types of contract that you can purchase based on NEC. We're also going to look at the ancillary documents to an NEC form of contract, so scope, collateral warranties, all those kind of things, pricing and risk, and how that's done, and then some of the risks, so the scope or works information. We're going to touch on subcontracting, and also a final point on caveats to your tenders and derogations. So if we can move on to the next slide, please, Jen. Yeah, so we do actually have a webinar and seminar. I think it's either next month or the month after, so October or November, looking at differences between JCT and NEC in terms of the risks and how they work. Fundamentally, where you would use a JCT would be what I would call straightforward build. So commonly we see student accommodation, nursing homes, offices, you know, that kind of build would typically be done under a JCT. Anything else, particularly anything engineering focused or, you know, groundworks, we would expect that to be under an NEC form of contract. So if we can move on to the next slide, please, Jan. So NEC is still the new contract. And the reason that I mention this is, and I think later on next year, so in 2026, we will be looking at NEC case law. And what we try to do is look at all the case law because it's a relatively youthful contract. There isn't a huge amount, so it's quite easy to keep up to speed with it. But it was introduced in 1993, contrast JCT 1931. So 1993 to some people in the room might seem a long time ago, but in terms of contracts, it's not. It's evolved, as has the JCT. You know, a new one will be issued every now and again. And we're currently working on NEC 4, which was introduced in 2017. We're now working on, I think, the 2020 version of it. And you probably will have some ongoing projects based on NEC 3 as well. I'd be really surprised if anyone is doing anything on NEC 2 at the moment. So if we can move to the next slide, please. So just a few things about NEC. So it's really innovative when it was introduced. If you compare it to JCT, JCT is traditional lawyers drafting, long paragraphs, quite legalistic terminology, but quite specific, as in, you know, one party does X. If they don't, then Y happens. If they do it, then Z happens. So very much dealing with responsibilities. NEC short sentences, present tense, and it more deals with procedural elements. And this is why we always say the NEC is a contract that you have to operate throughout the course of the works. You can't just put it in the drawer and forget about it. It's very process driven. So one party does X, the other party then reviews it and accepts or rejects it, etc., etc., and with timescales. So, you know, it is a contract that you've got to understand and follow. Gradually, the two contracts are in some respects moving closer together, and we'll see a couple of examples of that today. But bear in mind that the NEC contract a number of years ago was designated as the public sector contract of choice. And traditionally in construction, there's been a reluctance to particularly notify claims for extra time, extra money through the course of the works, and quite often it's seen as being too commercial. With NEC, it requires this, and it's part of that process-driven part of the contract, and the fact that it's supposed to be no surprises for the paying party. So we sometimes end up with a sort of a little bit of a circular problem where the paying party requires the NEC contract to be used. The contractor doesn't want to notify claims, but the contract does require claims to manifest themselves, not as we often see with JCT right at the end of the project with the final account. So if we can move on to the next slide, please, Jan. So I did this slide, so you'll see it as benefits of NEC to the client. So it's not the contractor or the subcontractor, but in some ways, this does apply to contractors and subcontractors. So the first point is we've got consistent drafting across the different contracts. So we'll see all the lists of contracts, and it's wider than JCT, and the drafting is more consistent. And that ties in with the next point, flexible procurement. So the contract we're focusing on, the engineering and construction contract, and the subcontract of the same title have certain options for pricing, which we'll come to later today. But the core clauses, the fundamental clauses all remain the same for the engineering and construction contract, and also for the subcontract. It's just the pricing elements that change, which makes it a really easy contract to use once you've got to grips. So once you've done one pricing option, it's relatively easy to move to another. Whereas, of course, with JCT, each pricing option is a different contract. The no surprises point for clients, we've already referred to that, and tied in with that is that there are penalties if there are surprises. So basically, time limits for contractor and subcontractor to notify claims, and if they don't comply, if they don't notify or don't notify within the time limits, then they're penalised financially, and it's quite a severe penalty, which might sound harsh, but you know, this is all part of that no surprises. So you're being given a contract where the client, the paying party, is saying, if things aren't going to plan, I want to know today, not, you know, in X months' time. Tied in with that is the proactive project manager, it's management. It stands to reason if you have to notify claims, if the client wants to know what's happening today on site, then it's got to be project managed by all parties properly. And linked to that is the collaboration. So the first clause in the contract is that all the parties, including the project manager, who's the contract administrator, the paying party, so including the project manager, has to act in the spirit of mutual trust and So that's effectively, you are required to collaborate. It doesn't change the risks. So, that doesn't mean that, oh, well, mutual trust and cooperation, so we shouldn't submit claims, or, if those claims are rejected, then we've just got to accept it. It just means that you've got to act honestly towards each other. So not particularly high bar, but you're supposed to collaborate. Now, in terms of case law, it's rarely that the mutual trust and cooperation is going to be something that you will be awarded more time or money on, but it often helps to keep this, these last bullet points, the no surprises, notifying claims, proactive project management. It helps to keep that going. So if you've got a client or a PM who isn't operating the contract properly, you can refer to the mutual trust and cooperation and say, this isn't what you're supposed to be doing. It's breach of mutual trust and cooperation. It's a breach of contract. Next slide, please. So a horrendous slide. Don't switch off, please, because we can separate it out. It's actually not as bad as it looks, honestly. So these are the contracts contained in I think we've got 16. So if you look at the first 4 to start with, they are all engineering and construction contracts. The first 2 are the contract and the short form contract. So they're for contractors engaging with the client. The short form is for small works, a bit like the minor works JCT. The third and the fourth are the subcontracts. So so there's a subcontract and a short form. Now, we've already said that there's a lot of crossover between the contracts. If you were to compare the contract and the subcontract in this first 4, you would pretty much find that they are a duplicate of each other, except, of course, for the terminology, because one talks about client and contractor and the other one talks about contractor and subcontractor. But apart from that, they're pretty much the same, which is more so that they are more the same. This doesn't really than the JCT contracts and subcontracts are. And again, it makes it really easy. If you've operated on a contract, converting and doing work on a subcontract is pretty easy because you already know all of the clauses. So then if we look at the next 4, so we've got term service contract. So the top 4 are for a particular project, build a tunnel, carry out some infrastructure works. The term service contract is, as it says on the tin, really, it is for a term. So typically 2, 5, 10-year contract to carry out specific work. So, housing association repair works, done on a call-off basis, local authority road maintenance works typically might be done under these contracts. And there's the term service and then the short form. The next 2, professional service contract and the short form contract. Again, this is something else I like with NEC because unlike JCT, you've got a professional services contract. So, if you're a contractor, you can engage your architect, your consulting engineers, your other professionals using this contract. And again, the clauses are very, very similar to the other clauses, to the clauses in the other contracts. We then have the next 4, so we've got contract supply short form. So that's as it says, somebody supplying bricks brings them to site, delivers them and leaves site. Somebody else installs them into whatever's being built. So it is just supply. Just note with the supply contracts, it's the same point as previous there's consistency there. It's ease of procurement. Note, though, that the supply contracts do not come within the ambit of the Housing Grants Act. So no right to interim payments and no right to adjudicate. So that's something for the suppliers to be careful about. But just bear that in mind. There is, however, a right to a contractual adjudication in all of these contracts, which would most likely apply to a supply contract, but there are strict time limits for starting it. So it's pretty much within a month of a dispute arising. So, that is a really short time scale. So where are we now? Right. So then we have the framework contract. So that's probably the shortest of all the contracts. It's a fairly sparse document, and typically you see it used in conjunction with the term service contract. Then we've got the dispute resolution contract. That's basically for adjudicators. So if you get involved in that, you've probably in adjudication and probably have got your lawyers involved. And then the last two were introduced with the changes made that resulted in NEC 4 coming out. First one is the DBO, the design, build and operate. So it is what it says it is. It's a design and build contract. And then once the building is completed, the contractor also operates it for a set period of time, 5, 10, 15 years, whatever's agreed. And then finally, a slightly esoteric contract, the alliance contract. Probably the sort of ethos of these contracts has been around kind of on and off for at least 15 to 20 years. Basically, the idea is that all the key parties to the contract, so that would be the client, the project manager, the main contractor, the key subcontractors, particularly those with any design, most of the consultants, some of the key suppliers, would all sign up to the same contract. There would be one pot of money to pay for the works, probably on a target basis, very limited opportunity to claim extras, even less opportunity to adjudicate, because the idea is it's sort of almost run by committee, you work your way through. So it's almost like a super collaboration contract. And some of the interesting things are, one, project insurance rather than the parties, each having insurance. So it sort of avoids that duplication of insurance that we often see. So some interesting factors. I think with both of these new contracts, they will only be used for substantial projects. But, let's see, it would be really interesting from a lawyer's perspective to see the alliance contract being used more substantially. So next slide, please. So other documents part of the NEC package, we've got guidance notes, which I often talk about. Very good just for checking what they say about a clause, but sometimes they also refer you to elsewhere in the contract where a remedy is given for not complying with a clause. So sometimes it helps to resolve some of the less clear points in the contracts. In NEC 3, we had a book of flowcharts, which is helpful, if that's how your mind works. Although because it's process driven, we do end up with multiple pages of flowcharts for individual issues. And then also NEC runs a Q&A. So if you sort of did a search, this would come up, and it's sort of agony aunt type queries. I've got this situation site. This is what the PM says. This is what I think. What's the answer? So it's not, I mean, I don't think it would be helpful in an adjudication if you produced, the NEC response. It would be of interest, but I suspect an adjudicator would take the view, that that's for them to decide. And of course, it's not like case law, because case law has been determined by judges, and is binding on future issues. But it can be quite helpful if you can find a similar situation to one that you have. And of course, if you have an issue, and you want to get across your point, and the Q&A covers that issue, it might persuade the other party that they need to pay, give the extension of time, or resolve whatever the issue is. Next slide, please, Jem. Okay, so looking at the ECC, the engineering and construction contract, at high level. So this is, as I said, the ECC, but of course, what we have already learned is that most of the other contracts have similar provisions, and a similar high level index. So first of all, we have some core clauses, and we're going to look at those in a bit more detail later on. They apply to every contract you enter into, subject to, fourth bullet point down, the Z clauses. Now, the Z clauses are the schedule of amendments that we often see with JCT, drafted by the law firm representing the client, or possibly, the client's own drafting. So they basically make changes to the NEC form of contract. Note, as it says there, over the last few years, we've seen a huge increase in extensive and detailed amendments, rather than it just being what it was kind of 10 years ago, where there may be some additional points put in. We now see detailed amendments of specific clauses, spanning kind of 20, 30, 40 pages. Second bullet point down, we have the dispute resolution clauses, W1 and W2. So that will be found towards the back of the NEC form of contract. We've got W1 and W2 because this is an international contract. It's not just designed for UK. W1 is for projects abroad and projects that do not come within the ambit of the Housing Grants Act. So that's supply contract, and some types of construction work do not come within the Act. For example, oil and gas construction work does not come within the ambit. So W1 applies, and that's where you have those strict timescales for adjudicating. So be really careful about that, because if you miss those timescales, you are time barred, and you cannot then, you can't proceed to court or arbitration if you miss the timescales. However, W2 is the process where the Housing Grants Act adjudication provisions apply. That says that you can adjudicate at any time, which is what the Housing Grants Act requires it to say. So generally speaking, you will be dealing with a W2 dispute resolution clause, but it is something to be careful of when you're negotiating your contract. We also have secondary options. So you'll notice we've had clauses W. So we also have, third bullet point, secondary option clauses X and Y. We're going to look at X in a bit more detail, but they are what I would call the commercial clauses, which are optional. They may not appear on every project. So for example, parent company guarantee, performance bond, collateral warranties, they are things that the client has to say, yeah, I need all of those, or no, I don't, or I just need some of them. The Z clauses we've covered. We also have a schedule of cost components, which is basically, it's right at the back of the contract, and it's basically a shopping list of what contractor, subcontractor is entitled to claim and how it claims it. And it applies to compensation events. So the compensation event covers any extra work. and any extra time. So by comparison to JCT, it's changes and variations, extension of time and loss and expense. It's all three of those. And in addition, the schedule of cost components applies to the option E pricing mechanism, which is a cost reimbursable mechanism, which we will come to later on. And we also have, I think this is probably right at the end of the physical contract, the contract data parts 1 and 2. So in all pro forma construction contracts, there is a bit that the parties have to fill in: names, addresses, relevant contact details, price, duration, how to, price the extras, etc., etc. So this is that bit. Contract data part 1 completed by the paying party, so the client or the contractor in a subcontract. Contract data part 2 is completed by the party carrying out the work. Really important that it's completed properly, particularly part 2, because a lot of that is about payment. So if there are blanks where there should be pounds or percentages, then quite often that's sort of deemed to be a 0. So make sure, please, that you do complete it thoroughly. Next slide, please, Jen. Okay, so ancillary documents. So that slide that we've just looked at the sort of high level index for the contract, the physical contract itself. So my, is this the one? Yeah, my NEC 4 here, that's what that covered. In addition, you need extra information, as we usually do in construction projects. The key one being that first one, the works information, now under NEC 4, called the scope, which is basically setting out what the project is, what is the work that is to be done. We also have site information. That is relevant as to things like the ground conditions and as to the extent to which a contractor might be entitled to more time and money, a compensation event, if those conditions in the site information prove to be different once the contractor's on site. We will look at that in more detail when we look at compensation events, which I think is February next year, 2026. Don't get too excited because it is quite limited, but there is the option there, unlike JCT, where ground conditions is just the contractor's risk. Provision for other documents, so collateral warranties, performance bonds, parent company guarantees, etc. Also, we might have an activity schedule or a bill of quantities. You'd never have both, and you might not have one. And we'll see later where you would have one, but it depends on what kind of pricing mechanism you have. So the activity schedule goes with a fixed price, and also a target contract. The bill of quantities goes with a remeasurable contract and also a different type of target contract. And then finally, there might be an accepted programme appended and sewn into the contract. Might be, hence the question marks, what the contract says. So one of the things about NEC is that it is very prescriptive regarding programmes. So the idea is you start off with a base programme that both parties have agreed. The programme is updated through the project, and any compensation events, any extra time through compensation events can then be impacted into an up-to-date programme. So you'll be aware that none of that is included in JCT, and sometimes we barely have a programme submitted throughout the whole of a JCT. NEC is very different, so you're likely to need a programmer where you wouldn't necessarily for JCT. However, that might sound quite onerous, but it is then helpful because it helps to justify extensions of time, rather than the sort of quite vague way we tend to do it with JCT. And obviously you're not, you know, this isn't the direction anyone wants to head it to, but if there is a dispute, it means you have the base programs, you have that evidence as to what was going on site at the time. And the alternative, and what we commonly have with JCT, is that we have to engage an expert programmer once a dispute has arisen, and the first task they have to do is sort of go back, use the evidence that they have, and recreate the history of what actually happened on site. And then, and only then, can they start to impact the delays, and see who caused the delay and what was the cause of the delay. So, in my view, in lots of respects, whilst, we will need an extra program, we will need a programmer to assist in an NEC project. I think it is helpful, and I would assume that if you are the paying party, you will have this in mind in any dispute, because certainly in JCT, parties have the lack of a programme in mind as being a huge hurdle for a claiming party. So if we can have the next slide, please. Okay, so these are those core clauses. So those first clauses in the contract, they apply to every contract subject to the Z clause amendments. So if you look down there, clauses 1 to 9, they are probably all clauses that you would expect to see in a construction contract. And you probably, hopefully, you will agree that they are the core or the key clauses. So the first one, general, it's the definitions plus the sort of admin. How do we communicate? Who communicates with who? What are the timescales for responding to communications? Number 2, contractors' responsibilities. That is, you will find that also in JCT, also, albeit different terminology. 3, time. So that's basically programming and timescales, and completion dates, etc. 4 used to be called testing and defects, which I think kind of is a better description. So it's testing during the works at completion and post completion as needed, and defects both before and after completion and how they're remedied and who pays, etc. Payment, clause 5, which is obviously critical. 6, compensation events, so the extra entitlements, time and money. So that is contractors and subcontractors' route to claiming. And I think, as I've said, I think it's February, we've got a whole seminar on that, because there are grounds for compensation events, and also there's a process to claim. Both are super important. 7 is title, pretty short section, basically looking at who has title to goods whilst they're until they're paid for, until they're installed into the facility. Now, 8, liabilities and insurance. And finally, 9 is terminating the contract, usually for default. So usually it's default by the party carrying out the work. So they are the core clauses. Obviously, as I've said, be careful about Z clauses, amending them, which is pretty prevalent at the moment. So if we can move on to the next slide, please. Thanks. So if you recall from that first slide, or one of the earlier slides that we looked at, we also next have the X clauses. So there's a selection here just to give you an idea. So X is 1 and 2. These are opportunities for the party carrying out the work to make extra compensation event claims. So 1 is for inflation. We all know about that, unfortunately, from the last few years. Without that clause, so the X clauses that apply are set out in that contract data part 1 that the paying party completes. So contractors, subcontractors need to review that contract data part 1 to check that the X clauses that they require are included. If X1 and X2 aren't included, then contractor, subcontractor isn't going to get any compensation event in these for inflation or changes in the law post-contract. X is 4, 13, 14 and 16 there. Basically, the extra security for the paying party, parent company guarantee, performance bond, advance payment bond, retention. X's 5 and 7 deal with sectional completion and delay damages. So damages if the contractor doesn't complete on time and isn't entitled to any extension of time via the compensation events. X15 and 18, again important to the contractor or subcontractor in a subcontract. X15 is the limitation of liability for the contractor's design to reasonable skill and care. Without this, arguably, contractor's liability is fitness for purpose. That's a problem for contractors because their professional indemnity insurers will not cover them for fitness for purpose. They are only covered for reasonable skill and care. So this is only optional because in some instances, a contractor might be engaged under an NEC without having any design liability. So effectively, the paying party has engaged consultants to carry out the design, and the contractor's work scope is just to do the work, i.e. not to design. If there's no design, then X15 isn't required. If the contractor has a design responsibility of any sort, even if they are going to subcontract it to subcontractors or their own consultants, this clause X15 needs to be included because ultimately the buck stops with the contractor in any claim made by the client. So even if the contractor can then make a claim against a subcontractor or a consultant, it's likely that the subcontractor or consultant will only be designing to reasonable skill and care, and therefore any element over and above that to the fitness for purpose, that will have to be borne by the contractor. So that is a really serious point that the contractor, subcontractors need to check when they're reviewing the contract and make sure they don't fall foul of it. X18 is quite a nice limitation of liability clause. It's not essential. If contractor's willing to have open-ended liability, then it won't be used. But I wouldn't have thought that's a good business model. And, you would want, I would imagine, to try and limit your liability in some ways. Options X and 9, so these apply to NEC 4 only. So they are undertakings to clients or others. What's that? Well, it's collateral warranty, basically. And option 9 is transfer of rights. Again, that's copyright. And also X22, again, introduced with NEC 4, so doesn't apply to the other contracts, is early contractor involvement. So, keep an eye on that. It's intended to be used with options C and E, their pricing options, which we're coming on to. But I think in the current market, hopefully we'll start, parties will start to use this. Essentially, it allows the contractor and subcontractors, if they're engaged on it, to be paid for that early contract involvement before the parties are ready to sign up to a contract with the price. So it allows the contractor to do work to work out what the proper price is going to be, probably carry out some site investigation, possibly carry out a bit of design work and get paid for all of that, rather than what currently seems to happen, which is the contractor does all that work at risk. And, you know, it then makes things difficult when the parties are trying to enter into a contract. Next slide, please. Okay, contract data part 1 and 2, I think we've covered that already, so we can move on to the next slide. Okay, so these are the different pricing options. So we've already seen in that middle column in the little chart, reference to activity schedule and the bill of quantities. And we've also seen references to options A to F. So basically we can get rid of option F. Option F is for a management contract. So it's very rarely used. And obviously, you know, it's priced as a management contract. So then if we look at options A to E, A is one end of the spectrum, E is the other end of the spectrum. So A is basically a fixed price contract, E is cost reimbursable. All the others are sort of a hybrid in the middle of it. So your option B is a fixed price with a bill of quantities. So it basically is a fixed price, but with some wriggle room to adjust that fixed price if the bill of quantities on remeasurement isn't needs to be adjusted. Option C and D are both target contracts. So where you have a target price. So how it works roughly for both of them is you have a target price which is set in the contract. And if there are any compensation events as the project goes on, the cost of those compensation events are added to the target. In the meantime, work is being carried out by the contractor. They're submitting their interim payment applications, probably on a monthly basis, and they are effectively paid on an option E basis, a cost reimbursable as they go along. And at the end of it, at the completion of the works, you total what they've been paid on the cost reimbursable basis. You look at what the target is, and you're either in a pain gain or gain situation. So if the target was 10 million, 2 million of compensation events, your target is 10 plus 2, 12 million. If the cost paid as the contractor has carried out the work comes to 11 million, then you're in a gain situation. There's £1 million to be shared between the two parties. How is it shared? Well, the percentages will be set out in that contract data part 1 and part 2. The reverse applies, obviously, if you're in a pain situation. So that's very roughly how options C and D work. There is a whole session on this. I think it is next month. It's either October or November. The activity schedule for option A is basically a shopping list of work to be done with sums next to them and a total. So the total is the fixed price. You need to be careful with it because the activity schedule is just for pricing. So when one of the items is being completed, so I don't know, piling, top of the list, £2 million for the piling. Once it's completed, contractor can submit an interim application to get paid for the piling. If, for example, the piling is not referred to in the activity schedule, but it is required in the works information, then the contractor can't turn around and say, oh, I want extra money because I haven't put the piling in the activity schedule. Contractor has an obligation to do the work in the scope, in the works information. The activity schedule is just about how it claims its money and what is the fixed price for the work. So if you think about it, your fixed price is to carry out the work in the scope, stroke works information. The salami slicing of it, the listing the items and the price for individual items is only to facilitate the payment. So we can move on to the next slide, please. Oh, actually, what I should have said about that is that those items, so the options A to F, if you're looking at the NEC form of contract, you've got your core clauses, and then after that, there's a couple of pages for each of options A to F, explaining specifically about the payment provisions and how those parts of the contract work. And that's why I say it's kind of seamless, because you've got the core clauses that apply to all of the different pricing mechanisms, but you've got specific provisions relating to the specific pricing. I think we can move on from that slide. Thanks, Jen, because we've covered it. We've covered all of that, so we can skip on to the next slide. Yeah, another thing to be careful of with NEC. So the second bullet point, we've covered quite a lot of this, but the second bullet point, up until any and including NEC 3, we had no final account, which sounds a bit odd if you just used JCT where there is a final account, but it did actually work. But one of the, where I said NEC and JCT sort of, are picking out points from each other's contracts and adopting them. One of the ones that NEC has adopted is the final account mechanism and the time barring provisions linked to it. So now in NEC 4, clause 53, we have final account provisions and time barring. So if one party submits the final account or final assessment when it is entitled to, and the other party does not respond to it within timescales, then that other party is deemed to have agreed that final account. Now, hopefully you can see how dangerous that might be, particularly, if there are compensation events that are outstanding, haven't been agreed, haven't been paid. So, just be super careful about that. And we will be looking at that in more detail later on in the year. And I think we've covered everything else, so we can move. Thank you. Yeah, we can move on for that because we'll cover that later. And that one, lovely. So the scope. Oh, can we just move back to the scope? Thank you. Yeah, so we've sort of briefly covered the scope stroke works information. What I wanted to say here was, well, the first point is just beware of ambiguities in the scope. That's the last bullet point. It might sound obvious, but scopes works information, quite often they're quite long documents, they're quite detailed, and it's amazing how often one provision will say something and then something, later on in the document, it'll contradict it. So unfortunately, I think there's no option unless the paying party is willing to reduce the scope. And sometimes I do think, they're unnecessarily long and cumbersome. There's no alternative but to look through it in detail, because of course, as we've seen, the scope is the work that the contractor will be required to carry out. And then the middle bullet point here is that many of the compensation events relate to the scope. So it's not like JCT where a lot of it is, if you think that you have been delayed, you claim, your reasonable period of delay. The NEC is more prescriptive, and it's more, if the paying party, hasn't provided something that it says it was to provide in the scope by the date it was to provide it in the scope, then it's a compensation event. So it's far more prescriptive. And you can't have a situation as you get in JCT where contractor says to the paying party, look, I need you to provide X, which you've said you would provide. I need it, 2 weeks today. And then it's not provided. A lot of it needs to be contained in the scope at the time of signing the contract. And again, we'll look at that in more detail in February when we look at the compensation events. Next slide, please, Jan. Ground conditions, all I want to say, so, all right, sorry, another risk. So this is just generally about the compensation events. Again, more detail in February, if you can wait that long. But fundamentally, that third bullet point is the most used compensation event. So it's clause 60.11. And it's a change in the scope, change to the works information. There are others. There's one for weather. Don't get too excited because ultimately, it's got to be really, really bad weather usually. Also, one that's not very often used is the next bullet point, 60.118, which is a breach of contract by the client or stroke employer. And for example, we talked about that mutual trust and cooperation, and using that if the project manager or the client isn't complying with the contract. And what you could do is then follow it up with a notification to say you're in breach of mutual trust and cooperation. It's a compensation event. It's unlikely to result in extra time or money. It might, it depends on the circumstances, but hopefully tactically it will persuade the errant party to pull up their socks and start complying with the contract. As I say, we'll look at all of that in more detail in February. So if we can move on to the next slide, please. Okay, so clause 26 deals with subcontracting. So this is core clause 2 of the engineering and construction contract. So how it works, it's a little bit odd, but clause 2 then becomes clause 20, 21, 22, 23. It sounds really confusing. If you look at the contract, it immediately becomes apparent how it's numbered. Possibly it's a sort of engineering numbering and it's just confusing to the lawyers. Clause 26 of those core clauses deals with the rules around the contractor subcontracting its work. And, as we often see, there are some rules and regulations in the contract as to what the contractor has to do in order to properly subcontract the works. We've also got, as we've seen, X8, which was that undertakings, which is collateral warranties, and may also require collateral warranties from subcontractors, consultants, etc. Third bullet point, beware of Z clauses, so they're the amendments which add extra responsibilities in terms of contractor engaging subcontractor, but that applies to all of the core clauses. And I think we'll leave so we've talk about the last two bullet points, the defined cost and the schedule of cost components and the shorter schedule. We'll look at that in more detail in February with the compensation events and also in March when we look at the schedule of cost components. So we'll just leave that cliffhanger until March. If I can have the next slide, please, Jen. Okay, so your caveats to your tender and your derogation. So what I'm thinking here, we've already seen that we have X18 is a cap on the contractor or the subcontractor's liability. So that might be adequate for a particular contractor or a subcontractor, but there may be a situation where invitation to tender is issued, contractor or subcontractor submits its standard list of derogations, caveats. So the ones I've seen tend to be things like we're not responsible for asbestos, we have no liability for that. And if we come across it, it's an extra, it's a compensation event. Ditto all ground conditions. Ditto all third parties, so all sorts of items like that, and usually there are a list of items where a contractor or subcontractor has been caught out in the past. The risk there is, and of course the contractor or subcontractor will base their price on that basis. So, if asbestos is discovered, it's a compensation event. We get paid extra money, we get additional time for it. So it's really critical that those requirements and caveats are incorporated properly into the contract. So the first rule is they must be sewn into the contracts one way or another. If they just go into the tender, and particularly, usually the tender will not then be sewn into the contract, they have no impact on the risks and liabilities, which is really unfortunate for a contractor where it has put forward a price based on them. So needs to go in the contract, and also you need to think about where they go in the contract. So this is the second bullet point, because typically the contract will say the core clauses, take precedence over any other clauses in the contract. And generally, actually, it says the NEC contract clauses take precedence. So if there's an ambiguity between the NEC and the caveats, then the NEC takes priority, and the caveats basically, we can just delete them, we can ignore them, they have no effect. So it's really important, and hopefully you can see that, to ensure that those caveats take priority. So they're just a couple of points to note. So I think if we can just move on to the last slide. Yep, so that's everything. We've got a minute for questions. Apologies. I'm happy to stay on if there are questions. I think Jen has a notice she wants to raise, but after Jen's notice, if you want to get off, you're not interested in listening to the questions, absolutely fine. Please feel free to do so. Thank you.
Well, thank you, Sarah. So as far as I can